Hi, this is Adam Hubble from Hubble Law in Tallahassee, Florida. I want to go over a durable power of attorney today so you understand why should probably be included in your estate planning documents. Before I explain a durable power of attorney, I'm going to tell you what a simple power of attorney is so you see the difference. A power of attorney, it grants authority to someone else to act on your behalf. And the simple power of attorney is usually used for one business deal that you have to do, and then it's over, and then it's no longer valid. For example, if I spoke with someone the other day who was buying a house, they couldn't make it to the closing, they signed a power of attorney to let someone else go sign the closing documents for them. So that was one instance. They closed on the house, and then that power of attorney was no longer effective for anything. Durable power of attorney, the durable part of it means that it will continue to be effective even after you're incapacitated. And you want that when you're doing estate planning, when you're planning out your estate, you want someone to be able to act on your behalf if you're incapacitated. So that's why it's durable. It holds up even after you're incapacitated. The durable power of attorney, usually you're going to grant a lot more authority to do a lot more different things. For example, you'll often give people access to your bank account so they can pay bills. They can do mundane things that have to be done, like just paying your bills if you're unable to do it. They can also manage investments. They can do a lot more involved things. They can sign contracts. If you grant them those powers, you can often allow them to apply for government benefits, and you can put certain things in, leave certain things out. But those are just some of the things that are commonly in a durable power of attorney. So it grants authority to someone to do all the things you need done, especially with finances if you're incapacitated. That's what a durable power of attorney does for you. One of the benefits of that, it can avoid a guardianship. A guardianship's a court process where someone can petition to have a guardian appointed for you. If you're incapacitated, and things have to be done, the physician or a family member might have to petition for you to have a guardian appointed. If you have a durable power of attorney and your agent can take care of things for you, you can avoid that guardianship process. So that's a huge benefit. And just some final notes about durable power of attorney. As with all the other simple power of attorney, it terminates upon your death. If you have an older power of attorney, there used to be something called a springing durable power of attorney in Florida, which meant that it wasn't effective until you became incapacitated. Those don't exist anymore as of 2011. So your durable power of attorney is effective as soon as it's signed and you have two witnesses and notarized. It will be effective, and that might raise a red flag. Do you want right now, while you're healthy and able to take care of things, do you want someone to have a document that says they can do all these things with your finances? Well, the document will be valid, but you don't have to hand it over to them immediately. This will be kind of based on your situation. You might keep that document, either leave it with your attorney if your attorney keeps your estate planning documents, or if you have it at home, lock it up somewhere. You can leave that durable power of attorney there, and as long as somebody knows how to get to those documents. So maybe you don't have to hand the durable power of attorney over to the person who's going to be making those decisions before you're ready for them to have it. Also, there's some what are called superpowers. Also, as of the legislative changes in 2011, you have to initial certain powers in the durable power of attorney. For example, the power to make gifts, the power to create trust, the power to change beneficiaries, etc. Some of those kind of big financial decisions and some other things. But whenever you have a durable power of attorney drawn up, there'll just be some lines to initial beside certain powers that you're granting your agent. And I mentioned it does have to be witnessed and signed by 2 witnesses, and it has to be notarized. And if you have other questions about a durable power of attorney, leave a question in the comments or give us a call.